Hi everyone and welcome to my YouTube channel Legal Vlogs by Sonal Alagh. I'm a practicing advocate in Courts of India and I'm also one of the founding partners of a boutique law firm, Alagh Kapoor Law Offices, based out of Delhi in India. The law firm is predominantly into dispute resolution, and guys, my forte or my area of specialization has been into insolvency laws, security laws and debt recovery laws. So guys, directly getting on to the point, the reason I'm starting with this YouTube channel is for the sheer purpose of exchange of knowledge. And guys, you are going to be the steering wheel for this channel because your wish is going to be my command. However, for today's video, the topic that I have chosen is very important and very relevant for everybody who is running a business in India, be it a small scale business or a large scale business. Anybody who is an employee with a company and that company is going insolvent, or anybody who is into any kind of vendor transaction with any company, in case of a real estate project, anybody who has invested in any real estate project, local authorities to whom tax are pending, anybody who has to get money from an Indian based company. This video is very important and the content that I'll be sharing will be very, very relevant for you guys. Also, not to miss all the commercial banks and non-banking financial companies who have lended money to small corporates, big corporates. The content of this video is very relevant for all of you guys also. So guys, today I'll be dealing with a concept known as Clean Slate Theory under the insolvency laws, which has been very, very recently reiterated and reaffirmed by the Supreme Court of India in a very recent judgment titled as Ghanshyam, Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Company. Guys, just a quick note that whatever judgments I'll be quoting, whatever data I'll be relying upon, whatever has been the source of my information, I'll be linking it all down in the description box for a happy reading for all of you guys. Okay guys, so let's just, before quickly jumping onto the clean slate theory, I just want to explain to all of you a very holistic view of how a basic insolvency process works in India. So guys, once a company is declared insolvent, the erstwhile management of that company goes out of picture and an interim resolution professional is appointed by the NCLT, that is National Company Law Tribunal, the adjudicating court, which decides whether a company is insolvent or not. So that very same court appoints an interim resolution professional, and this man handles the management of the company for an interim period till the corporate insolvency resolution process, that is the entire resolution process, comes to an end. A new bidder comes into the picture, the successful bidder who comes with a resolution plan, and his plan is approved by the NCLT. Till that currency of time, this man, the resolution professional, he handles the management of that company, and thereafter he gives the management of the company into the hand of the new bidder, the resolution applicant, the successful resolution applicant whose plan has been approved by NCLT, and thereafter that company carry forwards the management of that company. So this is a very holistic view that how a basic insolvency process in a very layman language works in India. So guys, now we come to the theory, that is the clean slate theory. Guys, this theory is based upon a legal maxim that all of us, not just all of us actually, across the globe in all law school, this is one of the very first few legal maxims that is taught to us. So guys, I'll try to pronounce it in Latin first and then tell you the English meaning. It is vigilantibus nor dormantibus jura subveniam. I'm sure I did a wrong pronunciation. But the English meaning of this is that law assists those who are vigilant about their rights and not the ones who keep sleeping over it. So guys, basically when any company goes into insolvency and when NCLT, that is the National Company Law Tribunal, admits the petition against the company and declares it to be insolvent, or initiate the entire corporate insolvency resolution process against that company, this middleman, that is the interim resolution professional who is appointed by that court, he issues a public announcement calling for claims from all the creditors. He issues basically a document which is issued in the English newspaper, it is issued in a regional language newspaper, it is published on the official website of that company, and it is also uploaded on the official website of IBBI, that is Insolvency and Bankruptcy Board of India. So guys, I'll be putting down the link to the IBBI website in the description box for an easy access. So guys, when a public announcement is issued by the interim resolution professional, he called for claims from all the creditors. So basically, if you're a creditor to that company owes you money in any manner, you ought to file your claim before the interim resolution professional or the resolution professional, as the case may be. So you have to file the claim before this man. Now guys, an automatic question comes is, what is the timeline to file this claim? When it comes to the timeline, there is a cutoff date that is mentioned in the public notice itself, in the public announcement itself. Now, statutorily, that time period is 14 days from the insolvency commencement date. So, hypothetically, if a company goes into insolvency on 1st of April and a public announcement is made on 3rd of April, the cutoff date that will be there in the public announcement is generally 14 days. So, that would be 14th of April. Now, guys, the question is that what if you don't file your claim till 14th of April? That is the cutoff date mentioned in the public notice. So, does your right to recover your money, the money that is legally owed and payable to you, goes for a toss? The answer to that is definitely no, that your right is not taken away from you. So, guys, let me tell you, till when can you file your claim? So, when the statute was enacted in 2016, Regulation 12 of the CIRP regulations, guys, I'm trying to avoid using a lot of section and regulations to keep it as simple and to target a larger audience. So a specific regulation, that is Regulation 12, it says that you have a right to file your claim until the resolution plan is approved by the Committee of Creditors. That is during the entire currency, 280 days. Statutorily it's 280 days, in practicality it is way more than 280 days. So until and unless that new resolution plan is approved by the committee, you have a right to file your claim before the resolution professional. Now guys, in 2018 there was an amendment in Regulation 12 wherein the time period was reduced down to 90 days. That is, you have a right to file your claim from the insolvency commencement date till the 90th day. Guys, so does that mean that if you don't file your claim within the 90 days, is your right to file a claim taken away from you? So this very question has been actually judged in a lot of judgments, and a lot of precedents have been established on this, that whether that amendment is directory or whether it is mandatory, whether the time period now stands as only 90 days. To name a few judgments, it is 21st Century Wire Roads Limited, Edelweiss Asset Reconstruction versus Edel Landmark Limited, SBI versus ARGL. For the sake of convenience, I'll be putting the link to all these judgments in the description box. So guys, basically in spirit, it has been held by the apex court itself that this amendment of reducing down the number of days to 90 days is only directory and not mandatory. So in spirit, in reality, this amendment has actually not made any change, and you still have a right to file your claim before the resolution professional till the acceptance of the resolution plan, like till the end of the entire corporate insolvency resolution process. You have a right to file your claim. So guys, in case anyone amongst the legal fraternity has an answer to the question that what was the reason for this amendment to bringing it down to 90 days, please just share your knowledge in the comments and let me know about the reason, because I just could not understand that why this amendment was brought at first place. So guys, now it only leaves us with a third kind of a situation where the resolution plan, that is the plan that has been brought by a new bidder to purchase the company or to solve the entire crisis of the company and to again make the company as a going concern, that resolution plan has been approved by the majority of the committee of creditors and has been upheld by the National Company Law Tribunal, and now that plan holds good. So, and you have missed the bus, you haven't filed your claim till the approval of the plan. Do you still have a right to recover that money that was legally owed to you, legally due to you? The answer this time is a no. Guys, this is the clean slate theory. So once a resolution plan is approved by the Committee of Creditors and upheld by the National Company Law Tribunal, and your claim or your money has not been a part of the resolution plan, it has not been considered in the resolution plan, your right to claim that money extinguishes. It does not exist in law anymore. Guys, I'm going to give you a very rationale, the entire rationale behind this logic behind the clean slate theory. So according to section 31 of the Insolvency and Bankruptcy Code, once a resolution plan is approved by National Company Law Tribunal, it is binding on all the stakeholders. It is binding on its employees, it is binding on its members, guarantors, everybody. And this such kind of a provision, guys, is very important to keep the dominant purpose of insolvency laws alive, that is revival of the corporate debtor, and make it a running concern again. Guys, once a new bidder submits a resolution plan, okay, so that resolution plan basically covers everything. It has the entire plan of payment to the creditors, it has the entire plan of how he's going to manage the company, how he's going to make it a running concern again, how he or that company is going to treat its employees, how they are planning to pay to all the creditors. So entire thing is there in the resolution plan. Now an automatic question is, where do they get this data from? So guys, remember the resolution professional who collect claims from all you guys, this very man under section 29 of the code has to draft an information memorandum and release it for all the bidders. Now guys, this document, the information memorandum, is the basis for drafting a resolution plan, because this document, the information memorandum, it contains everything from pin to plane about that company. What are the assets of that company? What are the liabilities of that company? Who are the employees of that company? What has been the annual performance of that company for the past year? The annual sheets. What are the factories? Who all are the guarantors to that company? Like everything about that company is there in the information memorandum. And guys, basis this information memorandum, the new bidder drafts a resolution plan, strategizes that how they are going to bring this company back from the insolvency status, revive it, infuse funds into it, and make it a running concern again. So guys, this memorandum is basically based upon all the claims that are filed, and the legislative intent of making the resolution plan binding on all the stakeholders of the company is so clear that on 3rd of July 2019, they specifically brought in an amendment to clarify that even the central, state and local authorities are binding. The resolution plan is basically binding on the central, state and local authorities also. Guys, and they have also said in the very recent judgment, which has actually made me to do this vlog, Ghanshyam Sons, the Supreme Court judgment, I have already mentioned that I'll be linking it down. In this judgment, the Supreme Court has actually clarified that this amendment of 2019 is only clarificatory. That means that since the inception of the code, like since 2016 itself, once a resolution plan has been approved, I'm just reiterating, nothing new. Once a resolution plan is approved by NCLT, it is binding on all the stakeholders, central government, state government, local authorities, creditors, employees, guarantors, any stakeholder of that company. And in case your claim is not forming part of that plan, you have not filed your claim, or that your claim has not been entertained in that plan, your right to recover that money extinguishes, because the new company or the successful resolution applicant has to be given a clean slate, because he has drafted a plan. And if you continue with the litigations even after the plan has been approved, the entire purpose of having that entire process goes for a toss, because that person will be surprised with amazingly new litigations which was never informed to him at the time of making that resolution plan. So guys, it's very important that in case your claim is rejected by a resolution professional or is not verified in totality, like you are claiming hypothetically 100 rupees, he is admitting 70 rupees because he's being able to verify only 70 rupees, there is any dispute with respect to your claim, do not sleep over it. Go to NCLT, file your applications before NCLT, just fight for your money which is legally owed and payable to you, because if you sleep over it, your right will be extinguished. There is no other remedy. And also because of a specific provision in law, in IBC code, that is section 238, it prevails over any other law of the country in case of any inconsistency. So guys, if you lose your right over here, if your claim is extinguished over here, there's no other remedy available to you. It is very clear that at certain point of time, mischiefs were being done by the local authorities, the central authorities, wherein they used to continue the litigation against the new resolution applicant, the successful resolution applicant, the new company that purchases. They continue the litigations on account of some ambiguities against the new management also, the successful resolution applicant also. And therefore the legislature had to specifically bring in an amendment in 2019 to say that even local authorities who have failed to file their claim, their rights have extinguished now, and that company is a clean slate for the new company. So the legislative intent behind this is to freeze all the claims so that the resolution applicant, the new bidder, starts on a clean slate and is not flung with any surprise claims. So guys, as a result, in Ghanshyam Sums and Private Limited, the Supreme Court of India has very clearly said, and guys, I'm just reading the verbatim now, that once a resolution plan is duly approved by the adjudicating authority under subsection 1 of section 31, the claims as provided in resolution plan shall stand frozen and will be binding on the corporate debtor and its employees, members, creditors, including the central government and any state government or any local authority, guarantors and other stakeholders. Guys, now the very important part. On date of approval of the resolution plan by the adjudicating authority, all such claims which are not part of the resolution plan shall stand extinguished, and no person will be entitled to initiate or continue any proceedings in respect to a claim which is not the part of the resolution plan. Guys, so come on, say it again. I just started with it. Law assists only those who are vigilant about their rights and not those who keep sleeping over it. I know none of you said it. Never mind. So guys, this is a very I hope this was a very knowledgeable session, because I really wanted you guys to know that generally you ignore that company has gone insolvent, paisa डूब गया है, अब recover नहीं हो सकता. You need to be vigilant about your rights. File the claim at the right point of time. I forgot to mention that filing of a claim is a very easy process. These are standard forms available on the IBBI website. I'll be mentioning the link to the IBBA website in the description box. You just have to go on the website, go to downloads, download the form, fill the form, file it. It's a very simple process. Now guys, before I end this video, I really have to thank Shireen Kapoor for motivating me to come up with this video. She's also a YouTube legal blogger, a solicitor and a barrister based out of Canada, and one of the founding partners to Ace Law. Ace Law is a boutique Canadian law firm which is a one-point stop for all the immigration law queries. I'll be providing the link to their website in the description box. So guys, I hope this video was very helpful for you guys. Now comes the most important part to the video. Please express yourself in the comments and let me know what kind of content you guys want. I can continue with the vlogs on insolvency and recovery laws because that's my forte and I can do that easily. Or I can also cover other sectors of law. I can pick up cyber laws because that's a booming sector. I can pick up on white collar crimes, especially crimes like portfolio scams, portfolio funding that are being done by large scale builders to fool the banks. And we can have vlogs on arbitration laws. I can pick up some recent judgments and do vlogs on it. So guys, I'm completely open for constructive criticism. Let me know what I need to improve on, whether the content was up to the mark or not, and whether I should be more professional, whether I should tone it down, make it more casual. यार बस demotivate मत करना, because already बहुत ज़्यादा negativity है. We all are fighting the pandemic together. So let's just motivate each other, and I'll just give my 100% to bring good content with you. I'll try to upload a video every weekend. So guys, for now I'll be logging off, and don't forget to like, share, comment and subscribe, because मुफ्त में है यार, कर दो, पैसे नहीं लग रहे. Please subscribe. Thanks.